pretrial. My name is Sarah White. I'm here with my co-counsel Gigi and Sandy De La Terra. Together we represent the plaintiff, Ms. Andy Park. If Your Honor is ready, we have a few evidentiary matters to take care of before trial starts. We would like to enter a copy of the autopsy report in today's case, as well as a written confession of the defendant's child. All objections to these two documents have already been waived, so we'd like to just go ahead and offer the evidence. Would you like to see copies?
Oh, that's fine. No
Okay.
worries.
This is a copy of the autopsy, and right here we have the statement. Just for Your Honor's reference, this is a wrongful death suit. We're bringing a claim of negligent parental supervision against the defendant for a shooting that happened between the defendant and the plaintiff's children.
So at this point, just as a clarification, these are not yet entered into evidence?
We would like to offer them into evidence at this point.
And have objections to their admission also been waived?
Yes, Your Honor. They were ruled on for the stipulations and the orders on motions and whatnot.
And can we get a ruling on whether or not they're admitted at this time?
Well, of course, that being if objections have been waived, that's admitted.
Wonderful. At this time, Ms. Andy Park is ready for trial.
Good morning.
Good morning, Your Honor. May we make appearances for the record to
Please
begin?
proceed.
Good morning, Your Honor. My name is Tommy Duke. Along with my co-counsel to my left is Mr. Andre Hodge.
Good morning, Your Honor.
He will be giving the defense's opening statement today. And to my right is Mr. Gregory Dashko.
Good morning, Your Honors.
He will be giving the defense's closing statement in today's trial.
Well,
Now, we also have a few pretrial evidence, documents to send to the bench. For Your Honor's reference, we have the answer to the complaint. We have a notice of intent to offer character evidence signed by both parties. We have a copy of the special instructions. We have a copy of the orders on motions and eliminate signed by Judge Brian Jackson. We have a copy of the stipulations for Your Honor's reference, a copy of the statutes governing today's trial, as well as available case law. May I approach opposing counsel and tender to the bench in turn?
please proceed. And while you're doing that, I ask, I don't have my copy with me, if there happens to be an extra copy of the rules of evidence.
Of course.
Something tells me that these rules might be called into question in the next 3 hours.
Absolutely. Would you like two or just one?
Once a night.
Perfect.
I wanna move that box. Leo?
If Your Honor's ready, we can begin with opening statements.
Your Honor, one more question about pretrial. If we may ask about your preferences about movement about the well, approaching and opposing counsel, and the witnesses, as well as the bench.
I appreciate the courtesy. Please make yourselves comfortable, relax, meet casa.
Yes, Your Honor. With that, the defense is ready to proceed.
Thank you.
Opening, Your Honor. Today's case is about a shooting that should have been predicted and could have been prevented. The events of today's case, they start with the defendant, Hayden Durang. Hayden Durang is an only mother. She has one son, a child named Jesse. They live in Fairview, Midlands, and Jesse is 11 years old. He's in 5th grade, but what you're going to hear today is that he isn't your average 5th grader. He's been getting into fights at school. In April of 2010, he gets in his 3rd fight of the year. And the school has to suspend him for biting, kicking, and punching other children. What you're going to hear is that Hayden Durang, the defendant, knows about these incidences and that she's worried about her son. She knows that her son has been drawing pictures of guns, talking about firearms. She even thinks that her child is obsessed with guns. Her child plays these violent video games, first-person shooter video games. And they're war-themed, but they're not your average war-themed video games. They involve mass killings, where you shoot as many people as you can. And the defendant, she goes so far as to even say, thank goodness that we don't keep a gun in our home. here is that the defendant's next door neighbors, the Park family, they do keep a gun in their home. They have it for protection, and they keep it locked up in a safe in their bedroom. They have the combination to that safe in the file cabinet in their office. And on August 17th, Jesse Duran, the defendant's child, finds out about that gun. On August 17th, Jesse Duran, the defendant's child, starts screaming, "I want the gun, I want the gun." And the Park's babysitter sees this. He's alarmed. So he tells Hayden Duran, "Your child knows about the gun inside this home." The Park's babysitter tells Hayden Duran, "Your child wants to play with this gun. And I don't think that your child should be allowed in this home ever again." Hayden Duran talks to her child. And what she hears her son, Jesse, say is that, "I know the guns in my video games are fake. And that's why I want to play with a real gun." For a moment, Hayden Duran tries to stop her son and say, no, that's dangerous. But what she sees is her son shrug his shoulders and walk away. She doesn't follow her son. She doesn't tell him that he's going to be in trouble if he tries to get access to that gun. She lets it slip. And the very next day, what she does is she walks her son over to the Park's house. And she drops her son off at the Park's house to play that day. And she knows that her son is going to be playing at the Park's house unsupervised, playing with the Park's 11-year-old daughter, Sydney. She leaves her child, and moments after the adults are outside of that house, Jesse Duran, as you're going to hear, forces Sydney Park to tell him where the combination to that safe is. Sydney doesn't want to do it. But Jesse Duran makes her. And he takes that gun out of that safe. He puts a bullet in it. And what you're going to hear is that he raises it at Sydney Park's head. And he pulls the trigger. What you're going to hear is that the very next time Mrs. Park sees her daughter, Sydney's lying under a white sheet. The only thing that Mrs. Park can see are her two sparkly pink flip-flops, just poking out. Today, we're bringing a charge of negligent parental supervision against the defendant. And we're charging her with this because in this jurisdiction, you can hold the parents of a child accountable for their actions. So when a child commits a violent act, you can sue the parent. At the end of today's trial, we're going to ask that you find Hayden Duran liable. Because what you'll see is that what happened was predictable and preventable.
May proceed, Your Honor, please.
Andre Hausch, for the defense. Your Honor, opposing counsel, and members of the jury. Sydney Park knew about the gun. She knew where it was. And Andy Park did nothing. on August 18th of 2010, two 11-year-old children, Jesse Duran and Sydney Park, were alone in the home of Sydney Park's mother, Andy Park. That day, the two of them decided to play with Andy Park's gun. And Sydney Park knew just how to get it. She knew that the gun was inside of a safe, inside of Andy Park's bedroom. And she knew that the combination to that safe was just in the next room over, in an unlocked filing cabinet. So they took that gun from its safe, they brought it to the living room, and as they were playing with it, the gun went off, and it killed Sydney. Members of the jury, what happened on August 18th of 2010 would have been impossible if Andy Park had made sure that her daughter didn't know where the gun was and didn't know how to get it. In today's trial, you will hear that Andy Park had warning after warning that her daughter knew exactly how to get that gun out of her bedroom, and that again and again, Andy Park ignored those warnings. Now, the plaintiff in today's case needs you to believe that Jesse Duran's mother, Hayden Duran, was so negligent that she should be held liable for Sydney Park's death. She should be held responsible for Sydney Park's death. But in today's trial, you will see that it was not Hayden Duran who knew that those children had access to that gun on August 18th of 2010. It was Andy Park. Now, members of the jury, what happened to Sydney Park is nothing less than a tragedy. It weighs in the hearts of us all. It took Sydney's life, and it shattered the lives of those who loved her. But members of the jury, we cannot allow passion and emotion to inform our decisions. It must be set aside in favor of rational judgment of the facts. Now, as the defense in today's case, we do not have to prove anything before you today. However, we have chosen to take upon an affirmative defense. What this means is that we will prove to you in today's proceedings by a preponderance of the evidence, or simply more likely than not, that Andy Park's lack of actions leading up to August 18th of 2010 created an unreasonable risk to Sydney Park's safety. That Andy Park failed to take the reasonable precautions to keep her daughter safe. In other words, we are going to show comparative fault on the part of Andy Park. Now, in order to make our case for you today, we're going to be calling before you three witnesses. Our first witness, Jesse Duran himself, will come before you, and he will tell you exactly what happened on August 18th. How Sydney knew exactly how to get that gun. How easy it was for the two of them to get access to that gun. Our second witness, firearm safety expert Dr. Ash DeRosa, will come before you. And Dr. DeRosa will tell you that the manner in which the Parks stored their gun was unsafe in more than one way, that it created a risk to Sydney Park and Jesse Duran on August 18th, 2010. And finally, Jesse Duran's own mother, Hayden Duran, will come before you. And she will tell you that she provided her son with structure, with discipline, that she did everything in her power to make sure that her son understood the dangers of firearms. At the end of today's trial, my co-counsel, Mr. Gregory Datchko, will come before you, and he will ask you to find Hayden Duran not liable. Sydney Park knew about the gun. She knew where it was. And Andy Park did nothing. Thank you.
Just so everyone's on the same page, it looks like we got our all lost time of 1:35. The plaintiff calls their first witness, Jules Sebastian.
Morning.
Hello, can you introduce yourself?
Hi, I'm Jill Sebastian.
And how are you involved in today's case?
I'm the lead forensic investigator for Breckenridge County. On August 18, 2010, I was called to investigate shots fired where a young girl named Sydney Park, the plaintiff's daughter in today's case, passed away.
Before we speak about your investigation, I want to start with your qualifications. Can you tell us where you went to school?
Of course, I began my education with my bachelor's degree in criminology. I got that at the University of North Carolina. Afterwards, I moved on to get my master's degree at John Jay College, and that's whenever I entered into the Midlands Police Academy. From there, I graduated second in my class and became an associate forensic investigator. I worked my way up the ladder, and in 2010, I became the lead forensic investigator.
As lead forensic investigator, have you testified in trials before?
Oh, absolutely. I've actually testified in 30 trials, criminal trials, where somebody's freedom was on the line.
I want to start talking about the day of the incident, August 18, 2010. Can you tell me how that day started for you?
Oh, of course. That day began like any other day, but then about 10:06 a.m., I got a call from Detective Williams asking me to go to 23rd Maple Street, where apparently shots had been fired, and a young girl named Sydney Park passed away.
What did you do once you arrived at this location?
I began my investigation.
What do you mean when you say you began your investigation?
I began collecting evidence and preparing to run tests.
What evidence did you collect in today's case?
I collected fingerprints for fingerprint analysis. I collected the gun that was used on scene and I bagged it. I collected GSR, which is gunshot residue. I took those swabs and I bagged them as well. And I collected pictures and evidence for blood splatter analysis.
What did you do with this evidence?
Well, once I collected this evidence, I ran tests on it.
And what tests did you run specifically?
I ran some fingerprint analysis tests on the fingerprints I collected and the gun that arrived on scene, as well as some other fingerprints I lifted on scene. I ran blood splatter analysis tests as well as a GSR, which is gunshot residue primer test.
Are these the tests that are relied upon in your field?
Oh, absolutely.
And did you reliably apply those methods in today's case?
Yes, of course.
I want to talk a little about your conclusions now on the investigation. Earlier when you were explaining this to me, you used a couple of your assistants to demonstrate what occurred on the day of the shooting. Would that be helpful to today's jury?
Yes, I'd be more than happy to demonstrate. If you've got 2 people and 2 chairs, I'd be happy to show you.
Your Honor, may Sebastian step down?
Please.
And my co-counsel also.
Proceed.
Ms. Sebastian, can you direct Ms. White and Ms. Terra where to position themselves?
Of course. First, let me position these chairs just to show you exactly about where Jesse and Sydney were sitting. These are about 6 feet apart, ideally. Will you be Jesse Duran and sit right here? Will you be Sydney Park and come sit right over here? Thank
Your
you.
Honor, I would object to lack of foundation. We've heard nothing that this is in fact how the room is situated or how Jesse or Sydney would have been seated on the date of August 18, 2010.
So foundational evidence relative to
This representation of this witness's conclusions.
your response?
Your Honor, we have laid the foundation that this witness is an expert in her field, and if allowed to continue, she will be able to explain why they are in fact seated 6 feet apart.
Okay, it's not clear to me why you need to be an expert to figure out what's 6 feet apart, but go ahead.
Your Honor, we just have heard no foundation. Nothing's been testified to that this is exactly how the room was arranged on August 18, 2010. We cannot give this any credit.
Overruled, I think the jury can gather from the context. We've just established that this witness was in the room, and now she's just reconstructing first what she saw when she came in the room. I think it's evident from the context overall.
Yes, Your Honor.
What about your test that you ran earlier indicated that these 2 individuals were 6 feet apart?
I ran a sit and stripling test, which is after a gun is fired, sit and stripling is expelled from the gun and it travels in the direction of the bullet and deposits on objects in the room. On Sydney's body during the autopsy, I found evidence of stippling on her body, and the evidence of the stippling and the concentration of it showed me that Jesse must have been 6 feet apart from Sydney whenever the shot was fired.
After establishing the distance between the two individuals, can you tell us anything about what Jesse was doing at the time?
Yes, I can tell you that Jesse had the gun at the time, and Jesse, I found this from the fingerprints I found on the gun, as well as I found 2 fingerprints, or partial fingerprints, on the bullet casing, telling me that Jesse must have loaded the gun.
Objection, improper expert opinion.
Your Honor, we have just heard testimony from the expert explaining that she found partial prints from Jesse on both the bullets and the weapon itself. And if you're allowed to explain further, she'll explain how, if I may proper, that the witness was had the only fingerprints on these bullet casings.
May I respond, Your Honor? Your Honor, if I make an offer of proof, this witness cannot conclusively say whether those were Jesse Duran's fingerprints on the shell casing that was found inside the gun. And what she has just told us is that those are Jesse Duran's fingerprints. Your Honor, if I may be allowed to voir dire this witness, I will establish that the fingerprints she found do not meet her own standard of evidence to conclusively match these partial prints to any given subject.
Here's what we're gonna do. That's a perfectly valid line of cross-examination. It's premature for you to try to get her to testify relative to that piece at this point, because it's the plaintiff carrying the witness at this point. You also have some very important questions relative to sort of what conclusions this witness is capable of drawing and whether she's the appropriate witness to draw those conclusions. But I want to let a little bit more testimony in. I'm going to overrule your objection for the moment. Feel free to raise it again after we get the rest of the facts out of this witness.
Yes, Your Honor.
Can you explain to me how you concluded that Jesse was in fact the one loading the gun?
I concluded this from the fingerprints I found on the bullet shell casing. These were partial prints. I found an index finger and a thumb fingerprint. A lot of times I like to explain why they were partial using a pin cap. If you have a pin cap, that would be great, so I could show the jury why they were in fact partial fingerprints and not entire fingerprints.
Awesome. Maybe step back. Here, Miss Sebastian.
You see how this pin cap is cylindrical in shape? When I press my finger against this pin cap, I can't get an entire fingerprint, my entire finger on this pin cap. So you're seeing only a partial fingerprint would be available. This is to be expected whenever you're looking at cylindrical objects like this.
After establishing that Jesse was in fact holding the gun, can you tell us what she was doing with this weapon?
Yes, I can tell you that Jessie's right arm was fully extended with this weapon in her hand. And her arm was faced in a parallel direction to Sydney's head.
What about the test that you ran indicated this?
Well, I ran a GSR testing, which is gunshot primer residue. Whenever a gun is fired, the metallic particles are expelled back at the shooter. So when Jessie fired the gun, I was able to find gunshot residue, a high concentration on her right arm. And then as I moved further down her body, I found less and less. On her shirt, I found a very small amount. And then on his hand, I found left hand, I found an even lesser amount. The closer you are whenever you fire a gun, the higher the concentration, telling me that her arm was in fact extended and pointed at Sydney.
If Jesse was pointing a gun at Sydney, what was Sydney doing?
Sydney was actually looking away at the time at about a 30 to 60 degree angle.
And what about your findings showed you that?
I was looking at the wound analysis that told me that Sydney was looking away. The shape of the wound told me that Sydney must have been looking away at the time because the gun entered at like an oblong angle whenever looking at it, it's more of a oval shaped. So that told me that Sydney was in fact looking away.
What happened after the weapon was fired?
After the weapon was fired, Sydney must have started to turn her head. And then after it impacted, she fell on the ground.
I want to start first with what you said about her turning her head. What about your evidence earlier indicated that she was turning her head?
That would be the blood splatter analysis test that I performed. The direction of the blood splatter on the wound told me that she must have been turning her head in the case of after the bullet was fired because of the specific arrangement of the blood around the wound.
And what happened after Sydney turned her head?
After Sydney turned her head, the bullet must have impacted and made her fall to the ground. I'm sorry, I'm gonna have to ask you to get onto the floor. Can you lie on your right side? Yes. And she was lying in an east to west diagonal direction.
Is this how you found Sydney Park on the day of the incident?
Yes, this is how I found Sydney Park the day of the incident. She had a sterile white sheet placed over her, and I saw pink flip-flops sticking out at the end.
Thank you, Ms. Sebastian. May Ms. Sebastian be allowed to sit back down? Thank you.
Why don't you leave the chairs there for a second? You might need them for a while.
Oh, pass the witness.
You need to sit.
Oh, we'll be perfectly fine. We can go ahead and use this chair in here.
Okay, don't put yourself comfortable out there.
Okay, let's do that.
I think the defense wants to kind of maintain this position because this is what the jury's considering.
Absolutely. Okay.
Actually, Your Honor, I will not be needing these on cross-examination. My objection was satisfied. The foundation was laid in terms of this arrangement. So if counsel wants to return their seats at the table.
Very good. Off you go.
Wonderful. Thank you. Excuse me.
Greg Dashko for the defense, Your Honors. May I proceed?
Give me one more second.
Yes, sir.
Second.
Yes, sir. Good morning, Ms. Sebastian.
Hi, how are you doing today?
Doing well yourself?
Good, glad to hear.
Well, I just want to go over your investigation that you conducted in regards to this case.
All right.
You told us on direct examination you found some fingerprints at the crime scene.
Yes, that's correct.
I want to focus on the two partial prints you found on that bullet case you found inside the gun.
Okay, that's